here this morning to hear oral arguments in the case of State of Ohio versus Carl C. Honorable. Each party will have 15 minutes in which to present their case. In this case, the appellee, State of Ohio, has waived. So, Attorney Black, you have your entire 15 minutes. You won't be serving any time for a rebuttal. We are being visually and audibly recorded to be posted online, so please try to be behind the podium as much as possible. We have ready to brief and we're ready to proceed with the Attorney Black.
May it please the court, my name is Rebecca Black and I'm the attorney representing the appellant in this matter, Carl C. Honorable. Today I'd like to focus my remarks on the sufficiency and manifest weight arguments in this case concerning two of the elements of the charge of disrupting public services, which is a violation of 2904.04A1 in this case, which since A3 is also another common charge that's rather different and discussed differently in the case law, just making that distinction there. The two elements of the offense that we're looking at are, one, whether the phone was damaged or tampered with, knowingly or purposely.
What does the record show on that? That seems like a pretty important issue.
I apologize.
What does the record show in it as far as any damage or alteration of the phone? And you've got the one party saying it shattered, you've got, and your position is it was just the case was separated from the phone. What is on the record specifically concerning any damage to the phone?
That's where I think the record best, I think it's best to direct our attention to the exhibits themselves. There's exhibits 6 and 7 are pictures of the phone. I believe Officer Walters, who took the pictures, said it was where they found it. And it appears to be on a tabletop on top of a magazine. The case or backing is separated from the phone. The phone is sitting here, case is sitting here. When they flip over the phone, like the screen is not shattered, when they flip over the phone, you can see the battery in place. No one testified that the phone itself was inoperable. No one said
that the battery had popped out of it.
Correct. That was testified to, I believe, by the victim, if my memory serves me, who was a very unreliable witness at best. At one point, all she says was, he took it from me and threw it down. Then, when asked later on, she said it was broken. Then it was shattered into bits and pieces. And then the police are saying, well, she told us it was broken. Then we look at the exhibits, and in my unprofessional view, it looks like a fully operable cell phone. No one testified that they tried to turn it on, and therefore it didn't work. And that issue of whether or not the phone is off or on is important, considering this court's decision in State v. Tayse, T-A-Y-S-E, or some of the things I was looking at said it was E-S, so I apologize if I'm wrong on that one. In that
That
case,
was just where the phone was turned off. They said that was not
correct.
public services. Then you have Bedford, which is basically the keep away game. He took it, didn't give it back. That was not. These are a little bit different, aren't they? Facts in this case.
I submit that they're not all that different. When you boil down to the condition of the phone in those two cases, the phone was still available, the phone was still operable. We're looking at the phone is...
Let me ask you a question. If there had been an altercation, from what I read, and the phone was tossed, whatever it is, whatever happened, the phone got tossed, and her perception was something blew off the phone and I can't use it, I'm running out the back door. I mean, I suppose she could have grabbed the phone, but there was an altercation going on at the time, wasn't there?
He was not convicted of any domestic violence, any such thing.
I didn't say he was convicted of any, but there was an altercation going on. That's how the phone landed wherever it landed, right?
I I believe, yes, I believe that would be fair to say, I apologize.
So I guess my question is, in her mind, that phone hit the ground or hit the table, wherever, parts blew off and she took off because she wasn't able to use the phone. Is that interference?
I don't believe it is, because the case law, especially coming out of this district, does not look to the victim's subjective opinion, state of mind, things like that. Now,
What's your argument as to interrupting service though, when the phone was not accessible to her or available to her to call 911 once he throws it? Is that an interruption of services under the statute?
I do not believe that based on the facts of this case it is. One of the things Bedford says was something to the effect of the gravamen of this determination is whether or not phone service was interrupted or impaired in any significant way. And I submit that just throwing the phone down on the ground or wherever within the same room, it was all one open room is how she described the apartment. So it's not like some of the cases coming out of other districts in which the phone was thrown away and never found. It's not like another case that was a situation where the phone was just chucked, just thrown very far away. Basically it ended up in a neighbor across the street's yard and was not recovered until the next day by the neighbor who just happened to find it. In those two cases, there was found to be an issue of impairment and interruption.
Of course, she's in a position where she either leaves, I mean, one scenario might be, or tries to get her phone and gets injured.
That is one way of looking at it, but in this case, I believe that's not the correct way to look at it. And again, it comes back to the Ninth District precedent of, we look at the condition of the phone. If you look at Tace, arguably that phone was not available either, because the reason it was off was Tace had hijacked the car with a mother, whose phone it was, and her child in the car and was holding the child at knife point. Arguably, that phone was not available, but this court did not that phone was not available for use in the mind of the mother.
But it also wasn't, okay, along with what Judge Sikoski was saying. So the service is for the person who pays for the phone and pays for the service. You removed my thing from me. I no longer have access to that service anymore. You've deprived me, you've interrupted my ability to get to my service because you did something with my phone. So wouldn't that be interrupting with your service in a significant way?
I argue that it's not significant, because it can be, in this case, regained.
But in this moment, when I need it really bad to call 911, I don't have it.
But that's where we go back to Bedford. It was withheld for not a lengthy period of time. And this court still decided that it was not interruption or impairment of service. And in that example, I think, Your Honor, we could be looking at cases where a child gets angry because their parent takes their phone away. I don't see a difference between the two. I apologize. I don't have kids. It seems, yes. But there isn't a requirement of violence or anything occurring under 2904.04A1, just that it's damaged or interrupted or impaired with.
So you're concerned about what the ramifications of holding that, just taking the phone away in and of itself without somehow significantly interrupting the services, as you're saying, or damaging the phone or whatever, how that would be used in other scenarios.
Correct, Your Honor.
Maybe a good example would be two teenage kids playing keep away from somebody else's cell phone, taking a cell phone and playing keep away from another kid.
Yes, it would still be in that situation purposely or knowingly damage or tamper with.
Except for here, don't we have the victim saying, I'm going to call 911, and him taking the phone, throwing it. That's a little bit different than what we're talking about, with children getting their phone taken away, etc. My understanding, and I could be wrong with the record, is he grabbed the phone, she threatened to call 911, tossed it, she left.
Correct, but there is case law. It's actually out of the second district, it was mentioned in the appellee's brief. I'm surprised I'm quoting this, but State v. Thomas out of the second district. And I think even the 2009 State v. Robinson out of the Ohio Supreme Court mentions that you don't have to be calling 911 for it to be an interruption or impairment of service. That's not important. Because other people have tried all kinds of arguments about, well, she wasn't actually trying to call, like in the middle of a phone call, and then it was taken away. You don't have to prove intent to call 911. It's just, and that would be under A3, I believe, 2904.04A3. Because in that case law, you're looking at whether emergency communications itself was,
Impeded or interrupted.
yes, substantially. They use the word substantially as the key word there. So it's important when you're looking at the case law, as I found, to differentiate between the A3 cases and the A1 cases. I'd like to discuss Bailey, State v. Bailey, briefly. That was mentioned in the prosecution's brief. And as we've talked about, the defendant threw the cell phone away and it was never recovered. And I think in that case, the victim was left without any telephone service. I want to say that there were no other phones available in Bailey.
In that case here,
There was no testimony as to it, one way or the other. And we'd be relying on the implications of the victim's actions. Was she running to call 911, or was she running just to get away from the situation, or both? We can only surmise. And so I think this case just doesn't have the facts to support a conviction under 2904.04A1 based on the missing testimony. No one tried to turn on the phone when it was arguably evident that there was a battery in there, the screen was not cracked, just a backing or a protective casing was removed. It looked like a rubbery thing in Exhibit 6 and 7.
Was it just, okay, this is a question, people buy cases to go over the top of their cell phones, but there is a cell phone independent of that. I guess my question is, was it the back of the phone itself that came off, or just that protective casing around the phone that came off?
And that's what's confusing. When you look at the pictures, you can see clearly a backing that looks rubbery, like it's also a protective case. Like it's thicker than just one little sheet that often goes on the back of the phone.
But you can see the battery, so.
Yes,
obviously
you could see the
phone itself-
internal workings of the phone.
Okay.
But again, we don't know if that, just removing one piece from the phone, was that significant impairment or interruption of services. I mean, I also argue it's not even damaged. The phone itself should have worked by what we can see in 6 and 7, and we don't have any information to the contrary. Unless there are any further questions.
well, wouldn't that be tampering then? If the phone, in fact, I thought it was just a cover, but apparently if the battery was exposed, sounds like the back of the phone was separated from the phone itself. Almost like a split.
And that's where, I think if anyone's familiar with, I want to say it's like a Motorola phone or something where the case is built into the phone in a way, like it comes with it, case is one with the phone,
Case is
perhaps.
one
That
with
might
the
be
phone.
fair to say. If you look at it,
But is there anything in the record on that?
no. It's just exhibits, looking at exhibits 6 and 7.
Well,
It doesn't look like it's merely the back of a phone. It's more than that. But I don't think the phone itself was really altered in enough of a way.
so tampering in your mind means altering.
That is what this court held by looking at Black's Law Dictionary in Bedford, I believe.
Okay, I'm gonna let you out of that. Thank you. Thank you for your presentation today. The court will take the matter under advisement, issue a decision which we mail to both sides as well as post it to our website and get it.